Hello again. All right, now we're going to go ahead and jump into your Chapter 7 lecture. Now we're going to be talking about juvenile transfer laws and what it means when a juvenile is transferred to the adult court system. All right, so our learning objectives for this lesson are that by the end, you should be able to explain the differences in maturity between juveniles and adults, explain how transfer to adult court system takes place, as well as the different types of waivers that are available. We're going to use waiver and transfer interchangeably here. You'll be able to summarize blended sentencing and the different blended sentencing models that are available, to describe what an intermediate correctional system is for juveniles and what it would be like, discuss the death penalty for youth, as well as summarize the debate about juveniles receiving a life without parole sentence. So let's get into what the differences are between children and adults, if any. So they say that the juvenile court should maintain jurisdiction over youth until either 1, their deficiencies are corrected, or 2, until they have developed the mental and emotional maturity of adults. However, we know that research says the brain does not fully develop until a person is possibly up until the age of 25. So we cannot keep youth in the juvenile court system until they're 25. That would be ridiculous. We can, as I mentioned in Chapter 6, usually retain jurisdiction until they're 21. So maturity is defined as when a person responds appropriately to circumstances and their environment. So we know that the research says juveniles have a diminished moral, cognitive, and social development when compared to adults. Some would argue that this equals a diminished responsibility when it comes to committing delinquent acts. So juveniles that are in the juvenile justice system often have emotional problems and learning disabilities, which only makes it harder for them to take full responsibility for their actions. Research also shows that youth under the age of 15 years can manifest levels of impairment equal to that of an adult who is deemed incompetent to stand trial. So if an adult would be deemed incompetent to stand trial, how do we expect a youth who's acting with the same level to be responsible for their actions? And in that same sense, how can we transfer youth to adult court when they're acting with that diminished capacity? So transfer to the adult court system for youth means that the youth is going to be transferred to the adult court for trial and punishment, so sentencing. And juveniles can be sent to adult prisons if their case is transferred. In the United States, every year, more than 200,000 youth are transferred and prosecuted every year in the adult system. So there are 3 types of transfer that we have. There's judicial waiver, prosecutorial discretion, and statutory exclusion. We're going to go over all 3 of those. So the first is judicial waiver. This is where a judge is going to make the determination of whether a juvenile's case should be transferred to the adult court or if the case should be retained in juvenile court for processing and sentencing. It is the most widely used type of transfer, and there's a few criteria that are included to make this determination. So the judge is going to look at things such as what's the juvenile's age? What is their maturity level? What's their relationship like with their parents? Do they listen to their parents at home? Are they defiant at home? What's their school performance? What do their grades look like? Are they involved in any clubs? How's their behavior while they're in school? What type of relationships or ties do they have to their communities? And what's their behavior like in their community? What's their risk level? So we use those actuarial assessments to determine what is the risk level of this youth, 1, for safety of the community, and 2, what's the risk level that they're going to commit future crimes? And then, is that youth amenable to services that are available in the juvenile court? The next is going to be prosecutorial discretion. So this is where a prosecutor is going to make the decision of whether or not to file the juvenile's case initially in juvenile or adult court. There are certain criteria that they do have to follow. Typically, it's the juvenile's age, whether there was a weapon involved, if it's a felony offense, certain things like that. However, the prosecutor also determines which charges to bring forth against a youth. So long as the written allegation explains which it should, explain what the juvenile did, sometimes the prosecutor will amend the charges to a higher offense if they believe the allegations warrant such. So this means that the prosecutor can actually amend the charges to be one that is transferable. So critics argue that it gives prosecutors way too much power in deciding what charges they're going to bring and ultimately deciding whether that case is eligible to be transferred then to the adult court. And then we have statutory exclusion. So in this case, this is where certain offenses are excluded from being tried in juvenile court. And therefore, the youth must be transferred to the adult court system for these certain offenses. Or the age of juvenile court jurisdiction is set lower than 18 years of age. So we have these raise the age campaigns that have been going on in recent years across the country. And they've actually been able to make a lot of legislative changes to raise not only the minimum age, but the maximum age of juvenile court jurisdiction. So let me explain what I mean. For example, we'll take New York. In New York, they were able to raise the minimum age of juvenile court jurisdiction. So this means the minimum age at which a youth can be tried and charged with an offense from 7 to 12. So prior to this, youth as young as 7 could be sent to juvenile court for offenses. So they were able to raise that age to 12. So no youth under the age of 12 can be determined that they're a delinquent anymore. They were also able to raise the maximum age. So previously in New York, the maximum age of juvenile court jurisdiction was set at 15 years. So any youth over that age would automatically be sent to adult court. Seems a little unreasonable, right? If the age of majority is 18. So they were actually able to raise this age from 15 to 17. So let's look at this next slide here. This is the juvenile age of jurisdiction for eligibility to be transferred to the adult court system. It also gives you the main type of transfer type that's used in each state. So you'll notice a lot of the states have raised it to 17 now, although we have Texas who's still at 16. So these campaigns have been able to make tremendous changes in legislation so that we can retain more youth in the juvenile system and just give them that opportunity to be rehabilitated with our juvenile specific services. So there's also two other types of transfer that we need to discuss. We have what's called a reverse waiver and blended sentencing. So a reverse waiver allows a youth who's over that maximum age or jurisdiction to be sent back to the juvenile court for processing if it's determined that their needs are best served in juvenile court. And then we have this idea of blended sentencing, which we briefly mentioned in Chapter 6. This is where a juvenile is given both a juvenile and an adult sentence, and it can work in one of two ways. The first way is that the youth is going to serve the juvenile sentence. However, if they violate that, if they fail to comply with any of the conditions of the juvenile sentence, then the adult sentence is going to kick in. So it's saying, hey, look, we're going to give you a shot here. We're going to give you a chance. But if you show us that you're not amenable to the treatment and services that we can offer you here in juvenile court, then we're done. You're going to go ahead and just go and serve that adult sentence, which can be up to 30 years. And that works in another way. So the youth may serve the juvenile sentence until they reach that age of majority, which is typically 18, and then they're going to complete the adult sentence. So it still gives them an opportunity to receive some juvenile specific and age specific treatment and services, but then once they turn 18, they'll go ahead and serve that adult sentence out. But they're going to receive time served for whatever amount of time they served on the juvenile sentence. So what are the different criterias to waive a juvenile's case to the adult court? Well, we're going to look at things such as, what's the seriousness of the alleged offense? Only felonies are transferred to the adult system. Was the offense aggressive? Was it violent? Was there premeditation? or a willful nature on behalf of the youth? Was property or a person harmed during commission of the act? Is there evidence that if presented to a grand jury, that they would return an indictment on those offenses? So would they find that there is in fact probable cause that the juvenile committed these acts if they transferred the case? And there's another aspect to look at is it's desirable to hold one trial rather than two separate trials when the co-defendants of the youth are adults. So instead of having a trial for the juvenile in the juvenile system and holding a separate trial for the adult offenders, it saves court time, it saves court money, saves people time and money in having to present the case twice. So there's a desirability to have that case just heard once in the adult system. And then what's the sophistication and maturity level of that juvenile? Do they have a lengthy prior criminal history or a history with juvenile court? And can we adequately protect the public? And what's the likelihood of rehabilitating that youth if we retain them in the juvenile system? So once we make the determination through those criteria that we're going to go ahead and transfer a youth to the adult system, the prosecutor is going to file a motion with the court that they want to transfer the case. There's going to be held then a probable cause hearing. So the judge is going to make a determination if probable cause exists that the offender committed these alleged acts, and they're going to consider the following. They're similar to what was considered previously in the criteria to initially waive a case. They're going to look at what's the juvenile's risk to himself, herself, or others. What's the juvenile's level of sophistication and maturity in understanding not only the nature of their offense, but the possible consequences of their behavior. Did they know that they could be transferred to the adult system? Did they understand the gravity of the offense that they just committed? Because we know that youth are impulsive and they're irrational. Are they amenable to treatment, supervision, and rehabilitation in juvenile court? Do they have a history of committing other violent crimes? Do they have an association with a gang, or was there a presence of co-defendants? Did they commit the act alone, or were they acting with others? And what was their part in that crime if they acted with others? Were they the ringleader, or were they just tagging along for the crime? Was there premeditation to commit the offense? And now we're looking at childhood trauma. So trauma is a huge buzzword in juvenile justice today. Not going to get into the weeds in it here, but we're really looking at what happens to that youth as a child, victimization, trauma, physical, sexual abuse that could have not caused, but that could have exacerbated, leading them into a life of crime. It's also important to note that we can make a decision for decertification. So we've said that it's either waiver or transfer, they're used interchangeably, but you can also call it certifying a youth to adult court or certification. So decertification is when we can actually send the case back to juvenile court for processing if the judge determines that none of these exist. So how successful are waivers to adult court? Well, for one, it's important to note that it's not always the most serious and violent offenders that are being waived. Drug and property offenses are actually more likely to be waived than are violent crimes. Just let that sink in for a second. You would assume that it's our most serious, violent, hardened, criminal youth that are being waived and sent to the adult system, but it's not. There's a lot of felony drug possession and distribution offenses that are waived, as well as, yes, violent property crimes, but also just general felony property crimes that are waived. Waiver also does not deter youth from crime, but actually increases crime in youth. We know that youth are not generally deterred because of waiver, mostly because a lot of youth don't even know that they can be transferred to the adult system. And they're not specifically deterred from committing future acts, because most states have once an adult, always an adult laws, which means once a juvenile's case is transferred to the adult system and they're tried and convicted in the adult system, any subsequent offense, no matter how minor, I'm telling you, no matter how minor, They are now forever considered an adult, and they will be tried and charged as such. Transferred youth are also more likely to offend. We know that they have greater likelihood of being rearrested, and they show increased rates of recidivism. So we must ask, what is the purpose of transferring youth? I implore you to think about that. So these youthful offender systems. So youth who are sentenced in adult court can be either placed on probation, they can even have their case dismissed, which there's a majority and a good percentage that are dismissed. They can be placed in juvenile facilities, released to their parents, or they can be placed in adult prison institutions with adult offenders, which has so many negative effects in and of itself, which we'll get into. But youthful offender systems are this new idea that we can provide programs in institutional settings for youth that are focused on job readiness, training, and experience to enhance the self-esteem of youth and to help them establish ties to their communities for successful reintegration. So we know that employment is the #1 predictor of recidivating for juveniles and for adults. If we can get juveniles employed, we can lower their recidivism rates drastically. So let's look now at some Supreme Court decisions on giving youth the death penalty. So when a youth is transferred to the adult system, let me stop. In the juvenile system, a juvenile cannot be given a death sentence. They also cannot be given a life sentence in juvenile court. Now let's get into adult court. In 1976, in the case of Gregg v. Georgia, the Supreme Court held that the death penalty did not violate cruel and unusual punishment clause of the 8th Amendment for youth. However, a few years later, the court didn't directly address this, but they said that the chronological age of a youth is to be a mitigating factor that should be given great weight when making the decision of whether or not to give a youth the death penalty. Then in 1988, in Thompson v. Oklahoma, the court said that the 8th and 14th Amendments do prohibit the execution of a youth who is under the age of 16 years when they commit their crime. And then just the next year, the Supreme Court did set the minimum age for the death penalty at 16 years. So they specifically said 16 years, you cannot give anything younger than that, you cannot give them the death penalty. It wasn't until 2005, that the court said the minimum age for the death penalty is now 18. So they said that giving a youthful offender the death penalty is unconstitutional. You cannot do it. It is cruel and unusual punishment. And then it's also important to note that in 2002, the court said, which this was the terminology at the time that was used, so I just used the same terminology from that era. I know this is not politically correct nowadays. But the court determined that juveniles who are deemed mentally retarded cannot be executed. So at least they made that determination, but it's important to know that less than 20 years ago, we finally said, we can't kill youth. So interesting fact is that the last execution of a juvenile offender was in 2003. His name was Scott Allen Hayne, and he was 17 years of age at the time of his conviction, and he was 36 years old at the time of his execution. What a waste. What a waste of a juvenile's life. So what does life in prison look like for a juvenile? Well, we know that prisons are severe, they're harsh, they're crowded, they're dangerous places. A youth who's sent to an adult facility experiences higher rates of physical and sexual victimization and assault. Now it's important to know that this is not just at the hands of fellow inmates, but also at the hands of correctional officers, which is just terribly sad to consider. Their mental health issues are exacerbated, so are suicidal ideations, so youth are more likely to commit suicide in an adult facility. They're also going to receive fewer age-appropriate services. That's in relation to rehabilitative, medical, mental health, and educational, because these facilities were not built for juvenile offenders. We do have some, in Pennsylvania, for example, we have a youthful offenders program for youth who are charged as adults, where it's like an intermediate, as we discussed in the previous slide. It's an intermediate place where they're going to go, which has more age-specific services, but also can house those more serious delinquent offenders who shouldn't be housed with juvenile delinquents. These are now juveniles who are considered criminals. And youth are highly impressionable and they're easily manipulated, so we have to have concerns for the gang culture that's present in a lot of adult facilities, right? So there's this idea that these juveniles are so impressionable and they're so easily manipulated, they want to belong. We have this fear that they're going to be more likely to join these gangs, which we know is going to lead to more assaults, more physical assaults in prison. So now, once a juvenile is given a sentence of life without parole, what does the Supreme Court say about that? Well, in 2010, the court said that, which you'll see it as LWOP's life without parole. You may also see it with a J in front, which they call JLWOP, which is just juvenile life without parole. So in Graham v. Florida, the Supreme Court said that life without parole for juveniles in non-homicidal cases is unconstitutional. So if the juvenile did not commit a homicide, it's unconstitutional to give them life without parole. 2 years later, the court said you can't give a juvenile a mandatory life without parole sentence. The judge needs to make a determination that that youth is permanently incorrigible. That was the phrasing they used. That this youth cannot be amenable to any treatment or services, and there's just no hope, is basically what you're telling that child. There is no hope for you. We're going to give you life in prison. 4 years later, the courts retroactively applied that decision, which meant that there were over 2,000 youth that needed to be resentenced. Most of them were still given a life without parole sentence, but they still had to be resentenced for the judge to make that determination that they were permanently incorrigible. Now we have an interesting case which is not mentioned in your book because it just occurred this past spring. In this case, an individual who was charged and tried as a juvenile in the adult system brought his case before the judge and said, you need to make a determination of permanent incorrigibility before you gave me this life sentence. And the court determined no. The judge does not need to make a separate factual finding. They can make that finding as they're making their general decision and determination on sentencing. It doesn't need to be a separate finding with separate facts. They can use all the same facts in that case and say that this is why I'm giving you the sentence. I'm determining that you're permanently incorrigible. This just opens the door now for more judges to give this sentence without having to really make that separate determination, which is what we presumed the court was saying in that case of Miller v. Alabama. So in sum, we know that juveniles are cognitively, emotionally, and developmentally different from adults. There are 3 main types of transfer that we covered: judicial waiver, prosecutorial discretion, and statutory exclusion. Blended sentencing is an option that allows a youth to be given both a juvenile and an adult sentence concurrently. Intermediate correctional systems for youth are going to focus on job readiness, job training, and experience. The death penalty for youth is unconstitutional when they're under the age of 18. Juvenile life without parole sentences are unconstitutional for non-homicidal cases. And mandatory juvenile life without parole is unconstitutional. The judge needs to make an individualized decision that that youth is permanently incorrigible. So there's your Chapter 7 lecture.